Our houses are all buried in snow.
Good morning.
Good morning. How are you? Here we are.
Just having the time of my
I
life.
was really paying attention to how deep the snow is. If you look down people's driveways, you can really see how deep that snow is.
That's awful.
Has anyone taken a measuring stick? Or actually, you probably need a yardstick
I
to
think
see how
we're,
deep it is in a yard.
I think we're around 50 inches.
Really? That's out there right now?
Not right
No,
now.
totally.
No, I might know what's on
Totally,
there right
yeah.
now. Jackie and I went snowshoeing Saturday?
Sunday.
Sunday. And it was,
I tell you what, there's enough for snowshoeing.
there's enough for
Yeah,
Heck,
I would
you could
say.
snowshoe in the street.
Yeah, you can. If you can avoid the potholes.
Well,
No, the beauty
you know
is the
what?
potholes are
They're
all filled
full.
with ice now, so it's a nice smooth
I actually
surface.
thought about that
You
coming
know,
down
some
our
of our
parking
roads
lot.
are so bad.
But what are you gonna do? You can't fill them.
Well, you can't now. No. Wait
So-
until this spring.
I mean,
It's
going
going to be even
down.
worse with
It's
the
gonna be-
thaw.
it's gonna be horrible.
Well, and it's gonna be worse because all our money is being spent on snow plowing, which comes out of
Did they come out
the
of general
road
funds?
repairs.
Uh,
Yeah. So,
So anyway,
What
so
are you gonna do?
before we get going, I do need to give a shout out to Rick Hitt, who actually joined me at Starbucks this morning for early morning coffee. So Rick said he was going to listen this morning.
How early?
So I was there at 7:30.
That's not very early. Come on.
that's, God, your half your day is gone,
Yeah,
isn't it?
yeah.
Wow.
I was having lunch.
You know, I feel sorry for you. No, 7:30 is.
So if I doze off here,
That's okay. How could
It'll
you doze
be-
off? Because the subject matter for today.
I'm sure it will be scintillating.
More
Yeah,
than, more
there's
than
no way you could sleep.
scintillating,
Okay.
No way you
Well,
could sleep.
keep me awake.
Yeah, this has to do with what you started the conversation off with in terms of snow and ice and winter, because what a lot of people think, they think that they have a claim because they slip and fall on somebody's sidewalk, or they slip and fall going into somebody's business, or they slip and fall elsewhere on the ice and snow, and that would have been true 30 years ago before the law in Michigan started changing dramatically over the course of a number of decisions by the Court of Appeals and Michigan Supreme Court. And there's a really good, culminating, I would say, in a decision in 2012 from the Michigan Supreme Court that, and I told Laura I'd mention this morning, but you know, people have to realize that this is Michigan and it is winter, and there's apt to be ice and snow. And in fact, the Michigan Supreme Court in its decision, and I'll just read a bit from it, said Michigan, being above the 42nd parallel of north latitude, is prone to winter. A little bit of sarcasm there from the Michigan
Just a
Supreme
touch.
Court. And with winter comes snow and ice accumulations on sidewalks, parking lots, roads, and other outdoor surfaces. Unfortunately, the accumulation of snow, ice, and other slippery hazards on surfaces regularly traversed by the citizens of this state result in innumerable mishaps and injuries each year. This case tests the extent of a premises owner's liability for one of those winter-related accidents. In this case, the plaintiff recognized the danger posed by ice on a sidewalk, yet chose to confront the hazard in an ultimately unsuccessful effort to enter the premises. Plaintiff claims that the premises owner should be liable for her injuries, while the owners argue that they are not liable because plaintiff's accident occurred as the result of an ordinary, open, and obvious condition. The court went on to say, in many regards, this case is unremarkable, both in its simplicity and its frequent occurrence in Michigan, yet there has been some confusion surrounding the application of the open and obvious doctrine to wintry conditions. In Michigan, a premises possessor owes a duty to use reasonable care to protect invitees, and I'll just give a little side note here. Invitee is a particular type of one of three categories of people who are on premises. Has a duty to use reasonable care to protect invitees from an unreasonable, and I emphasize the word unreasonable, risk of harm caused by dangerous conditions on the premises, including snow and ice conditions. However, liability does not arise for open and obvious dangers unless special aspects of a condition make even an open and obvious risk unreasonably dangerous. This may include situations in which it is, quote, effectively unavoidable, unquote, for an invitee to avoid the hazard posed by such inherently dangerous condition. The ultimate result in this case was the Supreme Court said plaintiff you are SOL, you are sure out of luck. You gotta expect that these are wintry conditions. And the fact that this happened to be a fitness club that you were going to visit to exercise, and you had a contractual agreement with the fitness club to exercise there, you still had the opportunity. You didn't have to go in, you didn't have to traverse the open and obvious hazard. You chose to do so, and therefore the premises owner is not liable.
What if
So-
it's dark?
So no business is ever liable?
The court went on to say that
Okay.
simply because a condition may be inherently dangerous is not enough. It had to be, quote, inherently unreasonably dangerous. Really, the Supreme Court has severely limited the ability of someone to collect from a premises owner, even if they are a business invitee, and that's the highest classification of individual. Even if you're a person who's visiting the premises on a business purpose, that the duty of the premises owner is only to protect that visitor from an unreasonable risk of harm. And you
So
couple
weather does not fall into that?
weather does not fall into that
Okay.
category. If in fact the invitee has to traverse that area, not simply to go exercise, that's a voluntary task, but if they have no choice but to traverse that area, then the plaintiff might have a cause of action. But then it depends upon whether or not it's from a natural accumulation of ice and snow, in which case the premises owner is never liable, or whether or not the premises owner did something to increase the hazard from the natural accumulation. Could be having an eavesdrop.
What if it's ice on a parking lot, you've plowed it, but you didn't salt it?
Decisions in Michigan say you don't have liability. Again, the
And it's
expectation-
dark.
You actually have a greater liability if you salt it at a time where it melts and then refreezes and causes black ice. Then you've actually done something to increase the hazard. So sometimes salting is not the best alternative, particularly when temperatures are so cold that the
Well, it's good that
Thaw
they
it, but the
limited
water
that because
freezes.
in this litigious society, people may take advantage of that
Constantly.
purposely.
But
Fake falls.
But forget
No,
fake
I
falls.
know.
They wouldn't
That
do
woke you right
that.
up because you wouldn't expect that.
They-
I'm not even concerned about fake falls. Everybody slips and falls. And one of the other factors is contributory negligence. If you're, I don't mean to make this gender specific, but I don't ordinarily wear high heels. But if you're a woman wearing high heels and you're walking down the sidewalk in Jackson right now in the high heels and you slip and fall, you're going to have a doubly difficult time trying to establish liability on the part of the property owner.
Yeah,
because
but it's about
everybody
what you
knows
have
about-
on. I mean, come on.
Yeah, right. You can be fashionable, but that's
You have
also
to be
in certain
fashionable.
circumstances stupid. The other thing people think is, all right, Jackson has a city ordinance that says you have to clean your sidewalk within 24 hours after the end of the
Right.
snow event. Michigan courts have held that simply having a duty imposed by an ordinance does not create a private cause of action. So simply failing to abide by the ordinance simply makes you subject to a ticket for that failure, but it does not increase your liability of the person who's crossing that sidewalk.
So let's toss out weather. When is a business liable if you have an accident?
Let me give you, well, there's actually an even more recent case at the Michigan Court of Appeals that extends or talks about the duty of a landlord or a merchant, a retail establishment, for example, or an office, the duty that they have to people coming onto the premises, or a landlord has to a tenant.
Right.
And those duties are similar. The court talks about the line of cases that address negligence, and there's a higher duty because there's a contractual duty. There's a relationship now between a landlord and a tenant, similar to the merchant and the business invitee. And the duty there is to protect the person coming onto the premises from a dangerous condition. And there are innumerable cases in Michigan where some hazard has been created by the landlord, or rather a hazardous condition existed. The landlord is told about the hazardous condition, does not take reasonable steps to remedy that condition. Could be a faulty step on a stairway, a faulty step on an emergency exit, anything like that. And if the landlord, under Michigan law, landlord has the duty to make the premises, and I'm not talking about residential landlords, keep the property fit for human habitation, keep it habitable, and under Michigan law has a duty to prevent those dangerous conditions. And so the tenant has a better case against the landlord in many circumstances. Again, not arising from snow and ice. I want to differentiate between that versus other types of conditions. Now, in leasehold circumstances, for example, Laura and I, in the properties that we have, we, in our leases, undertake to remove the snow and do the lawn maintenance, et cetera, because we want to make sure that it gets done. However, many landlords, or at least some landlords, impose that duty on the tenants. And the decision from the Michigan Supreme Court dealt with that circumstance in which, or a recent case dealt with that circumstance, and the court said you can contractually pass that duty on to the tenant. So if the tenant had the duty to repair this particular condition, et cetera, the fact that it existed does not impose liability on the landlord. So you got a bunch of things going on. First, what's the relationship between the parties? Second, is there some contractual assignment of risk in that contract so that it passes from the landlord to the tenant?
Certainly the landlord would claim they know nothing.
Yeah, but you can take,
I
I
know
want to take this,
nothing.
I want to take this
What
one step
about
farther.
snow mounds? Right now, we're challenging snow mounds, you know. So I pull out of my driveway and I can't see because the mound, either from the street being plowed or us plowing our driveway, is so high, I can't really see until my nose gets out into the
All right, so
road,
so
and
now
I
you've
could
gone
slam
beyond
into-
natural accumulation of ice and snow, so that doesn't apply because now the landlord or the business owner has undertaken steps to create this mound of snow. So the next question is it an open and obvious hazard? What's the answer to that?
Well, certainly open, and it's certainly obvious.
Yeah, because I'm driving, I've got presumably good eyesight, and so
But
I
I
know
don't have
that this is
any
here.
responsibility to knock that mound down, so my visibility can be.
You might have a responsibility under a local ordinance, but that doesn't create a cause of action on the part of the person who carelessly goes out and doesn't pay attention to what's beyond that mound of snow. I mean, again, this is Michigan, it's wintertime, you've got snow mounds.
And this is probably nothing for us compared to northern Michigan, right?
We actually have more snow here than northern Michigan.
Even
has.
Gaylord?
Even
Every time we
Gaylord.
go through
I was in
Gaylord.
Gaylord last week. The amount of snow then was about the same as we have here, but we've been hammered with the last two storms. I was in Tawas on the east side of the state, and there was much less snow there than there is here. So it depends on where you are, but you expect snow, you expect the mounds of snow, they are unavoidable, and so the person, the driver, has to take extra steps, extra caution to make certain that they don't end up in an accident as a result of their own acts or omissions. Again, it would depend upon the particular circumstances, but under most circumstances, it's an open and obvious
What about if
hazard.
a municipality swipes your car because you chose to leave it in the road during a snowstorm, and they're trying to plow and get the roads
Well, they can't do
clear,
that.
and they accidentally hit your car or something?
And
I mean, I go down 7th Street and there's a car that's buried by snow. Clearly hasn't moved through any of the snowstorms.
I don't know the answer to that off the top of my head, but you have to start with the premise that the government is immune from tort liability unless it consents to that liability. There is a statute in Michigan that provides for liability of municipalities in the state for highway defects, but I doubt that falls within the exception to governmental immunity for tort liability, because I don't think it's a defect in the highway.
Or you're
Again, I've never
on a
confirmed that. I
4-lane
don't know.
road, like,
Are you telling me that, well, the city would certainly be liable, right?
I don't know. No, I don't know the answer because generally
If they hit the
municipality-
car?
No, generally, municipalities are immune from liability for torts, for injuries resulting from acts or omissions. The only time a municipality is liable for its torts is when the state has created an exception to that immunity. And I've never handled one of those kinds of cases, so I don't know what the answer is to that particular question. Maybe, but I don't know the answer off the top of my head.
Who would be liable? The driver?
Well, there wouldn't be any liability. The city would be liable, but it's immune from suit by virtue of the doctrine of governmental immunity. So there's liability, but you can't collect for it. So the question is there an exception from
The
governmental?
question is who
if you're
pays,
gonna leave your car on the
who
street.
pays for the car?
Yeah, the insurance company.
Yeah, and if you're gonna leave your car on the street, I guess you better make sure you have more than PLPD, right?
Well.
During this kind of weather?
That just doesn't
I mean,
ring.
first of all, it's not in motion, so I don't think no fault applies. The car's not in motion, it's stationary, so your own insurance company is going to pay for it. You bring a claim against the city, I don't know, we could ask Bethany Smith, the city attorney, what the answer to that question is. I just don't know. I've never handled one of those kinds of cases. If you guys want me to answer these questions, you got to give me a little advance advance notice, or else ask me
No,
something
we
that I deal
don't
with.
give you advance
Okay.
notice, because otherwise you monopolize the money.
Sorry about that.
Oh, are you here today?
Yeah,
Yeah, right.
exactly.
Yeah, keep it up, people. Look, I'm suffering from a cold, so don't test my patience this morning.
Play the violin music.
But as I started to say, the conversation also hinges upon the type of person that is on the premises. Are you a trespasser or a licensee, a person on premises for social purpose? There's a lower duty of care owed by the owner to a licensee or a trespasser, and a higher duty owed to somebody that's on your premises for a business purpose or is there as a contractual tenant.
Well, the insurance companies must be glad about this, because,
Oh, yeah.
I mean, I've heard of families suing each other just to get the insurance money.
Right, well, let me give you a good example. I tried a case, I can't remember if it was 1981 or 1984, it's been so long ago, but it was a woman who fell at a Frank's Nursery in Lansing and had a week-long jury trial, and I got a $340,000 verdict on behalf of a woman who broke her hip. If I brought that case today, first of all, I wouldn't bring that case today, because under the circumstances that existed in that case, it would have been barred by the open and obvious doctrine. And so the law has changed dramatically to protect owners of premises from claims of invitees, licensees, and trespassers. Much more difficult to collect for a slip and fall or a trip and fall these days. Which is,
But you got me on the snowplow thing.
I don't know, but I'm telling you, I
I'm
don't know the
mesmerized
answer.
by that one.
No, don't be surprised, because I told you I don't know the answer
Okay.
to it, so.
But it's
I'll tell you
interesting
what.
the number of people who are leaving their cars in the street.
Yeah, I was talking yesterday about one that had not moved in 6 weeks. I think the city finally put a ticket on it. It was still buried
Well, one
in
thing
snow,
to do is look
but-
and make sure it has a current license plate. If it doesn't have a current license plate, they'll ticket the owner, and then it will have to be removed, and if it's not, city will remove it. But
And I will find out the answer to that
Okay.
question and bring it with me tomorrow, and I may just
Tomorrow?
do these,
Where are you
or, I mean,
going
next
tomorrow?
week,
Next Thursday.
next Thursday.
Okay.
Look, I'll tell you what, I'm still suffering from this cold.
Well, I
So
just
don't-
didn't know
don't-
if Greg had a
don't
special
come
meeting
after
with
me.
you.
So anyway, I'll call Bethany, or I'll call some
Okay.
municipal attorney, and I'm sure that he or she can answer that question off the top of his or her head.
Because I believe the city should be liable if they hit your car.
I believe you have some beliefs that probably are not sustainable if you
and
actually looked at
they
them that
wouldn't.
carefully.
I mean, they certainly wouldn't want to hit somebody's car.
I understand that.
Okay. I wanna make
I'm
that
not saying
clear.
they hit it on purpose.
Right.
Well, they don't have to hit it on purpose. Let's just suppose a snowplow's going by and throws up gravel and it breaks the windshield on your car.
Right.
Yeah? Who's liable for that?
I just think people need to get their cars
That's the
off the
question
street.
that I
That's a
will
little
answer
different.
next week.
In
That's
this
okay.
weather, they need to get
Well,
their
no, it's
cars
no
off the
different. I
street.
mean,
Why,
because
that
if
would
I-
be different.
No, if they hit it with a plow, it's still, they didn't do it
It's no different
deliberately.
than you driving down the street and a stone pops up and breaks your windshield because of a truck is in front of you or something down a highway and it starts cracking. That's certainly happened to you, right? It's happened to everybody. In fact, I have a crack in my windshield.
He's shrugging his shoulders.
Maybe.
Here.
And he's even
I hate to tell you
smiling.
this, Greg, but on a
Is this
radio,
radio?
Yeah,
show, I
Jackie-
can't see you shrugging your shoulders.
Jackie can get it on video though.
No.
All right, so the market is.
Are you selling houses?
I am.
Okay.
So last week we talked about that we had a shortage. There are typically about 1,200. We have 700 and how many?
61.
61 houses on the market. It is a great time to get your house on the market. So call me. We have 4647 Westbrook, which is one of those condos off McCain. Western Schools, 46,000. It's 2-bedroom, 1.5 bath. Another Western School home we just listed is 4890 Slayton, a nice ranch. 3 bedrooms, 2 full baths, just under 1,400 square feet with a full basement, and that's at 124.9.
Where's Slayton?
Slayton is off of McCain. Or you take
McCain to Bunting.
you take McCain to Bunning and then Slayton. And then we have a price reduction at 200 North Thompson. Cute bungalow home, 2 bedrooms, 1 bath, 57,000. Call me at 780-3800 and let's get your house on the market.
ThinkingRealestate.com on the World Wide.